Hello everyone, my name is Dhruv. I am an intern at LEXIS and Company, and today in this video we would be discussing a very interesting topic, which is dissolution of a firm. Now I know that we should have talked about how a firm is made and different things, but being a part of a contract law, first we would be discussing the dissolution of a firm. Now, what happens when a firm got dissolved, or what are the modes of dissolution of a firm? We would be discussing this in this video. Now, according to section 39 of Indian Partnership Act, which says that the dissolution of firm between all partners of the firm is called dissolution of firm. Now, the dissolution of firm involves the complete breakdown of the partnership relation. In the dissolution of a partnership firm, the partners may, by agreement, provide for the continuance of the firm after its dissolution by death, lunacy, or insolvency of any partner. In such cases, the firm is reconstructed without any dissolution. Thus, dissolution of firm does not involve the dissolution of partnership. With the dissolution of partnership does not necessarily involve the dissolution of firm. So actually what it means is that dissolution of partnership does not means that the firm is actually dissolved. It does not means the dissolution of firm, but the dissolution of firm can result in dissolution of partnership. So today we will be discussing the modes of dissolution of a firm, which we can say that there are 4 to 5 ways in general, and we'll be discussing it. So dissolution by agreement. Now a firm may be dissolved with the consent of all partners in accordance with the contract between the partners. This was the first method or the first mode. Secondly, compulsory dissolution can be there. A firm is compulsorily dissolved by the adjudication as insolvent of all the partners except one, by the happening of an event which makes it unlawful for the business of the firm to be carried out, or for the partners to carry it on the partnership. Now, dissolution on happening of the certain categories, like there can be various reasons of a firm to getting dissolved. So subject to the contract between the partners, a firm can be dissolved by the death of the partner, the insolvency of the partner, the retirement of a partner, the completion of the adventure, and the expiry of the term fixed, which may be fixed when the firm was started. So the fourth mode which we would be seeing is dissolution by notice of the partnership at will. Now if the partnership is at will, then any partner can get the firm dissolved by giving notice in writing to the other partners of the firm. This was the most easiest way if the partnership is at will. Now the fifth can be dissolution by court. So the court may order the dissolution of the firm at the suit of the partner in any of the following ways. This can be done when a partner of a firm has become of unsound mind, when the partner of a firm has become permanently incapable of performing his duties as a partner, when a partner commits willful or persistent breach of agreement, when a partner is guilty of some of his misconduct, and when the business of a firm cannot be carried on save at a loss. When the such circumstances comes when you cannot save your firm actually. The last and the second last would be here, that when a partner has transferred his whole of an interest in the partnership into an outsider. When this basically means when a partner has involved a third person into this, which is obviously a breach of partnership. And the last mode would be when on any other ground the court is satisfied that it is just an equitable firm that may be dissolved. So this decision we left to the court. Now there must be there must be some doubts and some questions, that why the closing or the winding up of the firm is only known as dissolution. So actually there is difference between the term winding up and dissolution. So If we see first about dissolution, the dissolution of a company is recorded and registered by the registrar of the company, and the process of dissolution is purely administrative function, and the liquidator does not have any important role in the dissolution. And the fourth point would be that the dissolution must take place after winding up. Now, when we discuss about winding up of a firm, so it says that the winding of a company is heard and judged by the tribunal. There is no involvement of registrar in this. The process of winding up is purely functional. The liquidator has an important role in winding up, and after winding up, dissolution takes place. So, always in every dissolution of a firm, the process of winding up will be there, and after that, the dissolution will take place. Now, we will be discussing some of the famous case laws, which is Whitwell versus Arthur. This was a case of 1865. So what happened is that a partner suffered from an attack of paralysis that would have been good around the dissolution, but for the fact that the medical evidence showed that the attack was only temporary and he had already started showing the signs of improvement by the time of hearing of his partner's application for dissolution. So here the court can also hold or stop the dissolution. Now, the second case would be that Snow versus Milford. This was of 1868. So, what happens that a partner of a firm of bankers committed an adultery in the city where the business was carried on. Thus, adultery committed by a crime have been held sufficient grounds to order to make the court and the firm get dissolved. So the court issued that this firm should be dissolved as because one partner has committed a crime, and adultery was a crime at that time. Now, and the third case would be SL versus Hayward. So the court said that a partnership between two solicitors for their joint may be dissolved if one of the parties fraudulently sells out the trust funds and apply the proceeds to his own use. So this is the case of the breach of partnership, and in breach of partnership, obviously the firm gets dissolved. So that was all about dissolving of a firm or dissolution of a firm. Thank you.